Good afternoon, Mr. Kim.
Okay.
Nice to finally see you in person, Mr.
This is
Rittman.
Preventive Care Center versus Medical Advantage Group and Seth Bernard, docket number 19-937CB. This is the time set for hearing on third-party defendant Seth Bernard's motion for summary disposition. And if I could first have counsel's appearance for the record, please.
Daniel J. Rittman on behalf of Seth Bernard, Judge.
And Albert Kim, P70301, appearing on behalf of Medical Advantage Group.
Thank you. Mr. Rittman, your motion, you may go ahead.
Judge, I'm already aware that you've read our briefs and that you're probably ready to go forward. If I may, I'm not going to rehash what I put in my brief. I'm going to let it stand. But if you don't mind, I'll do a brief statement on. I didn't file a reply brief, but just a few comments on defendant's response, if I may.
Yes, of course.
Judge, if I direct the court's attention to page 6 of their brief, where the defendant states that the cases cited are non-binding. Also, the defendant asserts two legal theories. One, a issue of sufficient actions in creating a personal guarantee, and two, necessary actions. However, the defendant provided no support for either theory. There's no case law contradictory to any case law that I have presented to the court. I, on behalf of my client, cite two specific cases, precedent-setting cases that we rely on for this motion. Bandit Industries versus Hobbs, 463 Mich 504, 2001 case, which is obviously binding, precedent-setting, as it is a Supreme Court case, and I have a case for the court if the court wishes it. And Livonia Building Materials Company versus Harrison Construction, 276 Mishap, 2007 case. And as to the issues raised in these motions, these cases are precedent-setting, and what our issues are. For a personal guarantee to be valid, you have to show a clear intent and a separate signature by the individual to be bound to make that personal guarantee valid. We just don't have that in this case, Judge. Mr. Bernard, or Dr. Bernard, I should say, signed on behalf of the company, but he never signed anything that is even close to signing a document that supports an issue that he signed it as a personal guarantor. Defendant does reference on page 7 a Columbus sewer pipe case, an 1885 case, as to technical necessities. But in all reality, Judge, he fails to finish the idea in that case, because that was stated in Bandit Supra. The following sentence to the statement about niceties is, the point, however, and this is coming right out of Bandit, the point, however, is that a personal guarantee cannot be implied from language that fails to clearly and unambiguously reflect an intent to assume such a responsibility. And that was Bandit at 514. Judge, the Bandit and Livonia, as I've stated, require more than just a technical nicety, and that's not what we have in this case. At the bottom of page 7, again on defendant's brief, he does agree that the universal practice that having an officer sign twice is sufficient for a personal guarantee, but not necessarily a condition in obtaining a personal guarantee for Bernard. There's no explanation for that statement or no supporting cases. There's no exception to Dr. Bernard. This 9.1 paragraph that they threw in at the end of this agreement does not bind Dr. Bernard. And as the court would look under that particular condition, you can see where it says that it's being signed by the parties have caused the agreement to be executed by their duly authorized representatives, as identified below. And that's where we have the defendant and the plaintiff, the companies that were involved in this agreement, not Dr. Bernard. Again, Livonia, as we pointed out, sets the standard. You need a second signature that's on a personal guarantee to bind an officer or a company representative. And then further on the bottom of page 7, defendant makes the statement that, quote, went on to explicitly and unambiguously state the signer of the agreement was personally and unconditionally guaranteeing an obligation of PCC. That is not stated in 9.1. There's nothing in 9.1 that says the signer. 9.1 doesn't even refer to Dr. Bernard. It refers to somebody, I, or whoever number of people that were going to be involved. But there's nothing in any of these documents that support the position that Dr. Bernard signed as a personal guarantor. And just a little bit about, in my brief that we set it out, and we agree with defendant in his standard of review, that you look at the entire document to get the intent of the parties. Judge, there's nothing in this document from the start of it until you get to 9.1 that even suggests there is a guarantor, and certainly doesn't suggest that Dr. Bernard is that guarantor. With that, Judge, I would ask the court to rule in our favor, and thank you for your time.
Thank you. Mr. Kim?
Judge, again, I'm not going to rehash my brief as well. I will, I'll summarize it. But again, I think that the key thing comes down to, again, that I disagree with plaintiff's interpretation of Livonia in the sense that, yes, they cite that as a situation where a binding personal guarantee would be in effect and actually would occur. And also based on the factual distinctions that we set here in this matter, I think that what it comes down to, Your Honor, again, even with personal guarantees, whether you have double signatures, it's not something where personal guarantees are written throughout the entire contract and you have to continually remind the defender that he's signing a personal guarantee. He signed a document that clearly stated he was signing, there was language that said personal guarantee. The language within that particular section 9.1 clearly sets forth that he's personally being liable, and even making reference to looking at his credit records, which, again, whose credit records would they be looking at this point, Your Honor? I don't know how you could make any sort of confusion. Moreover, he individually signed each individual page of this contract, knowingly looking at every single page. And moreover, he filed this suit in Lansing. My client is located in Ann Arbor, even though the contract specifically states that it's in Lansing. I understand that, this is a contract. He signed it, maybe not the most favorable to him, but ultimately the contract says what it says. It's pretty clear and unambiguous that it's a personal guarantee. No matter how you want to frame it, it says personal guarantee. It says that you're going to be liable. It says we're going to look at your credit in order to make the determination as to whether or not we believe you're credit worthy. I think that the contract by itself stands on itself as a personal guarantee, and I don't believe that the defendant has provided enough evidence that he did not have the intent. The intent is ultimately what the contract says, and the contract is pretty clear.
Judge, if I may?
Yeah, I was just going to ask you if you wanted a rebuttal.
Yes, just a second. For one thing, Mr. Kim said that he signed every page. He may have initialed every page, other than the page that the personal guarantee is on. But now we're talking about evidentiary issues, factual issues. That's not why we're here. We're here based on a legal question of whether or not, based on the case law that I've supplied, that this personal guarantee is valid based on the two cases and the other cases I've cited, but specifically the two cases I've talked about. And as an officer of the court, I will tell you, the reason it's filed in Lansing is because I read it, and that's what the contract said. The contract said jurisdiction or venue was in Lansing. So that's in fact where where I signed it. Nobody disagreed with me. Nobody filed it for a change of venue. So I'm glad to be in Lansing, but that was me. Other than that, Judge, I don't have anything else.
All right, thank you. Well, I looked at 3 cases, and they're basically the ones the attorneys have talked about in order to decode this one. The first one is Geresy, Geresy, which of course is an unpublished opinion, where the trial court refused to impose individual liability because the individual defendant only signed, or defendants rather, only signed as members of the entity, and they didn't also sign individually, and then the Court of Appeals agreed with that. Then we've got Livonia Building Materials. That's a published decision, so that's binding. And it said, although we are not bound by Geresy, we find its rationale persuasive. And there, the court held that signing once as the president of the entity is not a personal guarantee. It's not a signature binding one as a personal guarantor. So the third one then is the Bandit case, B-A-N-D-I-T, and that's the Supreme Court case. And that was the faxed note where the court found that not only, the Supreme Court found that not only was the content of the note insufficient to show an intent to be personally liable for a debt, but the signature as well, Bill, was too informal to, as they put it, to demonstrate personal assumption of a grave responsibility. So in reading these 3 cases, to me it became apparent that we're looking for 2 different components here. One is there has to be some language in the personal guarantee that shows that the guarantor has an intent to be personally liable for the debt. And the second component is an individual signature in order to be personally liable. And, you know, Geresy lacked one of those. Livonia Building Materials lacked one of those. Bandit lacked both of them. In this case, one could argue that there's language in here in paragraph 9.1 that would indicate that someone had an intent to be personally liable for this debt. And you could argue that one of the necessary components is met, but very clearly the other necessary component of the personal individual signature is not met, and it is required. The defendant says that there's nothing in the document that made it clear that Dr. Bernard was signing solely in his capacity as a member of the PLC. Well, I very strongly disagree with that, because the paragraph right before the signatures, it says, in witness whereof the parties have caused this agreement to be executed by their duly authorized representatives as identified below. And then the signature block for Dr. Bernard has above his signature Preventive Care Center PLC, and then below that he has signed Seth Bernard D.O. So he has only signed as a representative of Preventive Care Center. He has not signed this document in his individual capacity. Again, while it might appear that the parties were headed down the road of contemplating a personal guarantee, they neglected to obtain a necessary signature. And it's a distinction that's important, because it's recognized in these cases that there are typically 2 signatures on these things, one in representative capacity for the contract itself, and then one in individual capacity for a personal guarantee. And I dare say that if Dr. Bernard had signed only in his individual capacity, we would be having a big argument about why he shouldn't be held individually liable for signing. And it might not be successful, but it could be, but it makes a difference, is my point. And here, you know, it's the opposite, where he's only signed as an agent of Preventive Care Center in representative capacity, a duly authorized representative. He has not signed in his individual capacity. I have to grant the third-party defendant Seth Bernard's motion for summary disposition. And Mr. Rittman, if you want to submit an order that says that it's granted for the reasons stated on the record.
I will do so, Judge.
Okay, thank you. Then if there's nothing else, that'll conclude our hearing.